Hi, everyone. My name is Summer Ingram Dean. I am the staff attorney at the Student Press Law Center. The Student Press Law Center is a nonprofit organization based in Washington, D.C. that provides free legal help and advice to student journalists and their advisors. Today, we're going to talk about copyright law, but at the center, we help students with a myriad of issues, including censorship, access to information and meetings, libel and privacy concerns. And so you can always contact us at splc.org/legal help if you have any additional legal questions. So I'm going to share my screen with you all, and then we can get started on today's presentation. So today we're going to be talking about copyright law. Copyright may seem like a bit of a heavy topic for student journalists, but questions about copyright are among the top most asked questions we field at the SPLC. Copyright infringement is a federal offense. You can be sued for damages in civil court, ranging from $200 to $150,000 per infringement. And under certain circumstances, it's a crime that holds potential jail time. On the flip side of things, you also have rights as a writer or a photographer and copyright owner yourself. So you better learn them so you can exercise them when the need arises. So what do we mean exactly when we talk about copyright ownership? Simply speaking, copyright is a property right. A person owns a copyright in much the same way he owns a car. Just like you can't use someone else's car without the owner's permission, you generally can't use someone else's copyrighted work without first obtaining consent. Additionally, just as no one but the car owner can sell, give away, or change the appearance of a car, generally no one but the copyright owner may legally transfer or alter a copyrighted work. The U.S. Constitution states that the purpose of copyright is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Copyright law encourages and rewards the creativity of authors and artists. If, for example, members of the public or a movie studio could freely copy the Harry Potter series without compensating or obtaining permission from author J.K. Rowling, she and other authors would likely be unwilling to invest the time, energy, and resources necessary to create books in the first place. Copyright, therefore, ensures a robust collection of original works available for public enjoyment and benefit, which is its main goal. The goal is to encourage creativity without fear. The next thing that's important for you to know is the general copyright rule, which is this. If you didn't create the work or if you don't own the copyright to it, you must get permission before using it. Many people mistakenly believe that as long as they give credit to the source, they are complying with copyright law. For example, if you get a photo from another publication and then credit that publication or that photographer for taking the photo. But if you didn't take the picture yourself or own the copyright to it, you must get permission to use it. Giving credit isn't enough as far as the law is concerned. Not everything can be copyrighted. Here are the criteria. First, there's originality. You need to have shown at least a small spark of creativity when creating the work. For example, arranging names in a telephone book alphabetically lacks the creativity necessary to qualify for copyright protection. Second requirement is fixation. The work must be fixed in any tangible medium of expression, which means that only works preserved in a tangible form, such as a book, newspaper, video, recording, website, or the like, will receive copyright protection. For example, if you perform a song for a friend but don't record it, notate it, or write down the lyrics, it won't receive copyright protection. Things aren't protected by copyright until they are in a state that is capable of being reproduced. The last requirement is expression. This is along the same lines as fixation. The point here is that thoughts and ideas that just exist in someone's mind are not copyright protected. If you just have an idea for a book, it won't receive copyright protection unless you protect it in some way. So which of these following examples can be copyrighted? An idea for a TV show that is a spinoff of the show Friends, a cartoon that runs with an editorial, a recipe for your grandma's famous apple pie, or a Just Do It slogan from Nike. The correct answer is B, a cartoon that runs with an editorial. An idea for a TV show that has not been expressed in any tangible way doesn't meet the fixation and expression prongs of the copyright requirements. A recipe, at its core, is simply a list of ingredients with the appropriate proportions and instructions on how to combine them. As wrong as it may seem, your secret family recipe cannot be copyrighted because it doesn't meet the requirement for originality. Courts have said that the identification of ingredients necessary for the preparation of a dish is just a statement of facts, which receives no copyright protection. Lastly, the "Just Do It" slogan doesn't meet the requirement for originality either. The words themselves, "Just Do It," aren't original enough to qualify for protection. Here we have some common examples of things that cannot be copyrighted. Ideas, facts, procedures, concepts, short phrases, titles, ingredients, and slogans are just a few. For example, in the previous question, the Nike slogan, "Just Do It," is just a short phrase that does not receive copyright protection. Therefore, it could be used as a headline or tag to illustrate a photo collage or even as the theme of a yearbook. However, using the "Just Do It" complete with the same typeface and the swoosh logo that Nike uses is probably a no-no because the design of the ad is sufficiently creative to meet that requirement for copyright. Other things that cannot be copyrighted are federal works. A work that's prepared by an officer or employee of the federal government as part of that person's official duties is not protected by copyright law. These works are considered to be in the public domain. This includes most federal government records, photos from FEMA, White House photographer photos, and the like. Some state and local government records are also not protected by copyright. A few websites where you can get works made by U.S. government employees include the White House, NASA, the State Department website, Defense Department, the National Park Service, and FEMA. This is a list of things that can be copyrighted. It's not an exhaustive list, but it will give you a good idea of some examples. Photos, stories, illustrations, cartoons, advertisements, sound recordings, works of art, musical compositions, and computer programs are all examples of things that can receive copyright protection. Now let's take a moment to do a little true and false. True or false? A work that does not display a copyright notice is not protected by copyright and can be used freely. What do you think? The answer to that is false. For works created after March 1st, 1989, a copyright notice is optional and does not affect the validity of the copyright protection. This means that if you see a cool image online and it doesn't have a copyright notice, i.e., the copyright symbol, it does not automatically mean that the work is free for your use. True or false? A work must be registered with the U.S. Copyright Office in order to receive copyright protection. That's also false. Formal registration is not required to receive copyright protection. Formally registering your work could help you in a legal proceeding, but it is not necessary. And in order to register for a copyright, you fill out a form, pay a fee, and submit a certain amount of copies of your work. No lawyers or any other specialists are required. So, how is a work copyrighted? It's simpler than you may realize. A copyright exists from the moment a work is created. The rules about how long a copyright lasts can get complicated. The simple rule to remember is that in the United States, works published before 1924 are in the public domain. Think super old things like Shakespeare plays. If something is in the public domain, you don't need permission before using it. For works created on or after January 1st, 1978, the copyright protection lasts for the life of the author plus 70 years. Next, we'll discuss who owns a copyright. As you can imagine, this is an important question to answer for student journalists. Generally, the creator of the work owns the copyright, including student journalists who work at campus publications. There is an exception to this rule, however. Under the work for hire doctrine, an employer owns the copyright of works created by his or her employees while working in the scope of their employment. This grants your employer the right to do pretty much whatever he wants with your work and prohibits you from doing the same. Most student journalists are not going to be considered employees of the school, so the work for hire doctrine would not apply. Rather, most student journalists fall under the category of independent contractors who own the works they create. In most student media programs, students volunteer their time and services. Even when you are being paid as a student journalist, you certainly aren't being paid enough to compensate for the amount of hours you actually work. Additionally, some students are paid on a per photo or story basis, much like a freelancer, which would suggest treatment as an independent contractor. Payments to a student in the form of a nominal stipend, tuition credits, or at a level that is below minimum wage would generally not constitute traditional employee compensation. Either way, it's important to know your classification when you start getting requests from former students or staff members to remove certain articles from the internet, because this could happen years after a story has run. It is important that every student publication have a copyright agreement that each staff member or contributor signs before their work is published in the newspaper, yearbook, magazine, or other school publication. On the SPLC website, you'll find a sample agreement that states that the student retains the copyright to their work, but is granting a limited license to the student media publication to use their work. This can be especially helpful in situations like a yearbook where you want to use a former staff member's photo, but the person has already graduated. If you have this agreement in place, you don't have to try and track down the former student. True or false? Adding a credit line on a copyrighted work is enough to avoid copyright problems. False. As we stated before, without actual explicit permission from a copyright owner, giving credit to the person who took the photo or created the work is not going to protect you from a claim of copyright infringement. So, let's say you found a photo you want to use in your magazine and there's no question it's copyrighted and you do not own the copyright to it. Then you'll need to get permission to use the photo. If you think it will be necessary to obtain a copyright to use a work, start early. That means you need to start planning before the week of your publication deadline. To find the copyright holder, either look at the copyright notice, for example, copyright 2015 Time Inc., or contact the Copyright Office that's located in Washington, D.C. You can search the registration records yourself on the website, or you can pay the Copyright Office to do the search for you. You can definitely make an initial phone call, but most copyright holders require a written request, which should include your name and contact information, the name and expected date of your publication, the number of copies you intend to produce, and the price you'll charge if you're charging. If, in the case of most of you, you are a nonprofit student publication, be sure to make that clear. You'll also need to include a precise description of what you want to use. You can even include a sketch of your plans. At the SPLC, we receive a great number of questions about using photos that you find online, so we'll cover that next. It's worth repeating here our general copyright rule. If you did not create the work and haven't otherwise obtained the copyright to it, you need permission to use it, even if you find it online, even if you find it through a Google image search. If you find photos through a Google image search, these search results do not transfer any copyright ownership to you. Google is not a stock photo agency, and you cannot purchase the rights of these photos unless you ask the photographer for permission or purchase the photo from the stock photography agency that holds the photo. The internet both simplifies and complicates things for us. If you feel tempted to just use a photo you grabbed from Google without permission, be aware that tracking the use of digital photos, music, videos, etc. is routine. Digital watermarks are secret tracking codes that are hidden or embedded within an image and are not visible to the naked eye. They are computer systems that search the internet for infringing uses of copyrighted images and then automatically generate and send a letter to whoever manages the website. While this kind of letter does not mean that you're getting sued, you certainly do not want to ignore it. If you do receive one of these letters, the first step is to remove the infringing material. This could be as simple as removing a photo that ran with an article. While this may not always get you out of hot water, it at least shows good faith on your part. Next, you need to research the organization or person making the claim and verify that they are in fact the legitimate owner of the copyrighted work. If all seems well on that front, it's good to know that the time frame someone has to sue for copyright infringement is 3 years after they became aware of the infringement. If more than 3 years have passed, a lawsuit can no longer be brought. You can always call in response to one of these letters, but it's a good idea to respond in writing and ask for more information. It is during this process that you can also let the organization know that your publication is a nonprofit, student-run publication. Many times, if you're dealing with someone reasonable, they will at least lower the price they're asking you to pay. Know that the higher profile photo you're using, the more attention it's likely to receive. Photos of celebrities, for instance, will always get a lot of attention. Instead of risking all that, here are some examples of places you can purchase stock photos or images. There's AP, iStock, Shutterstock, Getty Images, and many more. There are also a growing number of websites that make photos, videos, music, and other creative works free for download and republication. It's important that you always follow the terms of use of the website, including the terms of any Creative Commons license. Creative Commons is a big website that students use, and it's great, but be sure to read the terms of use for the works there. Many times, the requirements just state that you must give attribution to the person who took the photo. This is an example of a notice you might see with a photo on Creative Commons. Some require that you note if you've altered the work, even just by cropping a photo or taking an excerpt of something. Normally, it doesn't apply to more trivial things like changing the size of the font. Share alike is a copyright licensing term to describe works or licenses that allow copies or adaptations of the work to be published, but only if you do so under the same or similar license as the original. Some licenses require that you cannot use the photo for commercial use. These are just examples, but the point is that it is important to pay attention when you use these sites. You can always contact the SPLC if you have questions about the terms. Now it's time to talk about social media. You know that little box everyone checks when signing up to use a social media platform, but no one really reads? That's a contract. When you click agree and use the service, you are, for the most part, creating a legally binding agreement. The terms and conditions that accompany a social media site are the ground rules for your relationship with that site. They tell you who can use the site, what can and cannot be posted. We won't go through all of the social media sites, but we can look at Instagram as an example. The Instagram terms of service state that you retain the right to your photos and content, but also include language that basically says that by using Instagram, you are giving Instagram all the rights of an original owner of the content, including the rights to reproduce, distribute, and modify the content. They can even relicense your photos without your permission, which means granting a third party the right to do all the things listed above. Another thing to keep in mind is that you can violate copyright law on your own account by posting material that is not yours. In the terms of service agreement, you've agreed that you either own all the content you are posting or have sought permission to post it. So keep in mind, just because someone has posted content on their social media profile does not mean that they waive copyright protection. An interesting example and something to also keep in mind is that just because you are in a photo does not mean you own the copyright to it. A few years ago, Khloe Kardashian posted a photo of herself with one of her sisters to her Instagram account, which has millions of followers. The photo was captured by a photographer at Exposure Photos, who had granted an exclusive license to the Daily Mail. As a result, the photo agency sued Khloe for more than $175,000. The lawsuit was later dismissed. True or false? I can take a photo of Beyonce from Google or from another publication and Photoshop my head onto her body and print it in my school yearbook. False. In fact, you may be in more trouble because you altered the photo. Altering a word you are using without permission does not eliminate the copyright issue. There is one important exception to our general copyright rule, and that'll be our last area of discussion for today. Fair use. Fair use is an exception to our general copyright rule. In other words, there are certain instances where you are able to use a portion of a copyrighted work without permission. Fair use can be a little tricky, but there are 4 factors that the courts look to when determining whether something would fall into this category. We'll explore those next. These are the 4 factors courts take into consideration when determining whether the use of a work qualifies as fair use: the purpose or character of the use, the nature of the copyrighted work, how much of the original work is used, and the effect of the use on the potential market value of the original work. I'll talk about each of these in a little more depth in the next few slides. The first factor is usually the most important, and it basically asks, is the way you're using the work transformative? Does it change the work's purpose, character, meaning, or message? The more the way you are using the work transforms the work from its original context by adding new value, the more likely courts are to find that your use falls under the fair use exception. Non-commercial uses for purposes like news reporting, teaching, criticism, or commentary are more likely to be considered fair use. For example, if you use a photograph of a movie cover or a record cover to write a critique or review of that movie or record, that would likely be considered fair use. A word of caution about relying on the news reporting rationale for your fair use. Courts generally only find fair use where the work itself is newsworthy and using the work is necessary to tell the story. The next factor is the nature of the copyrighted work. As we discussed before, facts are not protected by copyright, so using works that mainly contain facts, like maps or biographies, is more likely to be considered a fair use. The third element is the amount of the original work used. It's a common misconception that you can safely use 30 seconds of a song or movie or 250 words of text without violating copyright law. This is false. There's no set portion of a work that you can use that will always count as fair use. In general, it's best to remember that the less you use of a work, the better. The last factor basically just asks if consumers would be willing to buy the new use as a substitute for the original work. Or, put another way, will your use of the work mean that others do not have to purchase a copy of the work? There are a few things you can do to minimize the effect of a use on the market value of the original work. For example, using an image at a significantly smaller size and lower resolution, or reproducing it in black and white instead of full color are a few ways to make it less likely that a consumer would look upon your use as a substitute for the original. This, as well as the other 3 factors considered in fair use analyses, are pretty fact specific, and thus it's hard to set out any hard and fast rules. Let's talk about some common fair use examples. Here on the screen, you'll see 2 articles with accompanying photos. The first is a review of a new Superman movie. Variations of this question are asked at the SPLC frequently. Sometimes the question is whether a student can include a thumbnail image of an album or a book they are reviewing in the student newspaper. Generally, anytime you're writing a review of something, be it a play, a movie, a book, an album, etc., Running a photo of the cover of the work or a still shot from the movie is going to count as fair use. Let's use our four-part test to see why. The purpose of the use is to aid in criticism or commentary of the work, while allowing readers to quickly identify what work is being discussed. The nature of these covers is artistic, and the amount of the artwork taken would be the whole thing, so those factors don't really help us. But the last factor, effect on the market for the original, weighs hugely in favor of fair use. Running a photo of a cover of a book or a still shot from a movie is not going to encourage people to buy a substitute for the original book or movie. In fact, if you're writing a good review, it could encourage people to purchase or consume the original work. Note that in our movie review example, however, fair use would not allow you to use a photo of a candid, would not allow you to use a candid photo taken of one of the movie stars and published in a celebrity magazine. The photo has no direct connection with the movie itself, which is the focus of the review. The second article on the screen is a single frame of the Charlie Brown comic that ran with an article about the death of Charles Schulz, the creator of Peanuts. Here, because they are just using a single frame of the comic strip to accompany a news article about the death of that comic's creator, fair use would probably allow for this limited use. Here are a few other common fair use examples, and we'll discuss whether they are right or wrong. A professor makes copies of one article for a periodical for distribution to his class. This would be a permissible fair use because the professor is only using a part of the work. Our second example is using a popular song as a background music for the intro to your school TV. This example wouldn't count as fair use, and it's a question we get a lot. Unless you are using a short clip of the song for a review of the CD from which it comes, using the song solely as background music would not qualify as fair use. You aren't using it in a transformative way and are using a significant portion of it. Parody can be considered a fair use when done correctly. The key is that the parody must mimic the original to make its point. Some general examples are changing some of the words of a Taylor Swift song to make fun of members of your senior class and printing them in the school yearbook. Even if it ends up being funny, what you've done hasn't made fun of the original work itself. On the other hand, if you change a small part of the song's lyrics to make fun of Taylor Swift herself, it could likely be considered a fair use. It's much more difficult to prove fair use if you're just borrowing from a popular work as a gimmick for attacking something other than the original work itself. In order to be safely considered a parody, the parody must be painfully obvious to the audience. The audience must reasonably perceive that the use is a criticism or a commentary of the original. Some school papers will print their April Fool's editions upside down to make it immediately obvious to the reader that something is different about this edition of the paper. Additionally, if you want to parody an original work, you must not use more of the original work than is necessary to conjure up thoughts of the original in the viewer's mind. Lastly, the parody must not directly threaten the market value of the original work. If the public will purchase the parody instead of buying the original, then that will weigh heavily against considering the use as fair. An example of parody we saw here in DC recently was when fake Washington Posts were handed out on the streets of DC at the beginning of 2019. The front page of these papers claimed that the president was resigning and had done so by writing a resignation message on a napkin in the Oval Office. The extra-large headline read, "Unprecedented." The fictional timeline of the paper credits protests like the Women's March with the president's abdication and includes a link to an action guide for people who wanted to pursue progressive causes. The paper was handed out in January, but the edition was dated May 1st, 2019, which should have been one of the first clues that something was off. Additionally, the tagline read, "Democracy awakens in action," rather than the traditional Post tagline, "Democracy dies in darkness." The pranksters also created a fake website designed to look like the Post website, which is the screenshot you're viewing on this slide. The Post legal department immediately responded, calling it trademark infringement and raised copyright threats. Their cease and desist letter to the group responsible for creating the fake paper and website points out that there is substantial likelihood of confusion between the fake copies and the actual post, including the fact that the masthead is identical, that neither the paper or the website state that the edition is fake or a parody or satire, and the fake online publication included links to content on the actual Washington Post website. So this is just an example of how something that is considered a joke can be taken out of hand. So that wraps up our conversation on copyright law. Of course, we haven't covered everything, and you may have more questions. As noted earlier, the SPLC website is packed full of resources on student press law issues, and you can talk one-on-one with someone on our legal team using our free legal hotline. And that is the link you see on the screen, splc.org/legal help. Reach out to us to schedule a phone call or fill out a form that will send us an email, and we can get back to you that way. Thank you for taking the time to join us for this presentation. I hope you found it helpful. Enjoy your time as a student journalist, and best wishes.